We're back this week with Stephanie Dobson. Stephanie is a lawyer, mediator, and online educator with Hankin Divorce Law and Mediation offices in Lloydminster and Edmonton. Stephanie, thank you for joining us on this cold day.
Ooh, thanks again for having me, Stacey.
I guess it's good to be inside, and we're going to be chatting about divorce because January is divorce month, which we have previously discussed. And today we're going to go into some of the myths that are that surround the divorce process. So we're just going to get right into it, Stephanie. And the first
Oh,
one is that
yeah.
you need your spouse's consent to get a divorce. So that's a myth.
Yeah, there's so many myths out there. How the heck do you choose five of them? So this is the first one that I thought of is yes, this is a myth. So in Canada, to get a divorce, you need to prove that there's been what's called a breakdown of the marriage. And there's three ways to prove that breakdown of the marriage. One is, which most people rely on, which is living separate and apart for 1 year. The second one is mental or physical cruelty by your spouse against you. And the third one is adultery by the other spouse. So in no case do you need your spouse's consent necessarily to proceed. If one of you wants to end the marriage, then all you simply have to do is to prove that one of these elements applies to you and you'll be eligible for a divorce. Obviously, there's a lot more complicating factors to it, but that's the basics.
All right. And the second myth, Stephanie, is that adultery will cost you everything.
Well, that does sometimes feel true emotionally, but on the legal front, that is a myth. And I call it a myth because the legislation does address in many ways that adultery does not have an effect on resolution to separation and divorce. So in many examples, so for example, here, spousal support. So the legislation says that you aren't going to receive less or have to pay more because of adultery. On the property division side, adultery has zero impact on how your property will be divided on separation or divorce. The split is going to be 50-50, subject to certain exemptions. And on the parenting side, although past conduct, it's called past conduct, may affect a parenting plan, adultery alone itself won't have an impact on you having time with your children or being a decision maker. One way that adultery does affect your divorce is that it could cause you to become eligible for a divorce sooner than the 1 year of separation.
Okay, and let's go into the next myth, Stephanie, which you kind of touched on a little bit in your last answer there, but child support. So I mean, it's a myth that if child support isn't paid, that the parenting time can be denied. Is that correct?
No, let's go on with our theme of this is a myth. So child support and parenting time are not necessarily linked together. So they're separate issues. So if there's a document requiring you to send the children to the other parent for their parenting time, then you're not just able to deny that time because child support has not been paid. There's reasons that parenting time may be denied. So for example, issues relating to safety of the children, but not for non-payment of child support. Now, if you're on the other side of the situation and you're being denied parenting time, that's equally not a reason to withhold payment of child support. I always say that if you end up having to go to court, it's best to come to court with clean hands. So if you have to pay child support, pay it, even if you're being denied parenting time. And if you're on the other side and you're to be receiving child support, even if you're not receiving child support, still send the child for their parenting time.
Okay, and the next one, and this is one I hear often, is that as soon as kids turn 12, they can decide which parent they want to live with.
I did a blog about this many, many years ago, and ever since then, it still is one of the top hits on our website, even today. So I guess it's a common thing that people think. So under the separation and divorce legislation, kids don't get to choose where they live until they're no longer under their parents' care and control as what we call children. Typically, that's going to be the age of majority, which in Alberta and Saskatchewan is 18 for these purposes. But the final decision is up to the parents, or ultimately, if the parents can't agree, then it's up to the courts to decide on where the children are going to be living. However, as the children get to be preteens or teenagers, they get a bit more feisty, and they may have a lot more to say about how where they spend their time. So I call getting the kids to have a voice, not necessarily a choice. There are ways we can bring the child's voice into the discussion. Sometimes there's a psychologist who will want to provide feedback to the parents. Lawyers and even the courts can sometimes provide that feedback, but generally speaking, it's going to be the kids having a voice, not a choice.
Okay, and the last one we're going to talk to today is something really that you specialize in. And the myth is that to get a divorce, I need to go to court.
Well, so on a very technical level, I'll say yes, actually, you do have to use the court process. You don't have to physically go to court or even virtually go to court, but you have to, in order to finalize your divorce to become legally unmarried, you have to have the court to stamp your divorce application. Since COVID, all of that happens by either fax or by email, or even there's an online portal now through the courts, sometimes that we can submit through. However, I call it a myth because when people ask if they need to go to court, usually they're talking about stepping a foot in the courtroom. So asking the judge to make a decision about something. All of the negotiations relating to your separation and divorce issues can be dealt with outside of the courtroom. So things like parenting, spousal support, child support, division of property can all be done through your lawyer or a mediator outside of the courtroom. Then the final resolution gets documented into a separation agreement and then court documents, which end up going through the court system through that online portal or the email format. So technically, you don't have to go to court, but you do end up submitting things to court just to get that final stamp of approval.
All right, Stephanie. Well, thank you for clearing those up. That's some good information as always. So we will be back again next week to chat with you more, continue our discussion about International Divorce Month.
Yeah, thanks, Stacey.